Greg Barnes, thank you so much indeed for your time. Did Julian Assange put at risk the lives of informants overseas who were trying to help the United States in security issues?
Well, the answer to that is no, Andrew, and it's no on two bases. First is that we've seen in the news overnight the Assange's legal team in London push back against the claim by the US government's lawyers that he in fact did put lives at risk. The sequence went something like this. He and his media partners, which included publications in the US, UK and Germany, were busy redacting names. There was the public, that was in 2010, late 2010. There was a publication of The Guardian, a book by Guardian journalists in early 2011, which included a password. This was picked up, I think, by a German newspaper at some point later in 2011. That's when Assange sought to speak to Hillary Clinton, then Secretary of State, to say, hey, you know, innocent, there are lives of people that are being put at risk if this goes ahead, if people access this password. Now, the second issue is that in the trial of Chelsea Manning, there was explicit and unambiguous evidence by the US military officials who said that they could not furnish the court with any evidence of lives, of individual lives which had been put at risk. That was consistent with advice that was given by the Australian military to the Gillard government in 2012, I think, or 11, which indicated similarly. So whilst the prosecution has put this up as a key element of its case, Andrew, the evidence and the way in which it's pushed back upon by Julian's legal team in London, I think, is very convincing.
Yeah, right. So the key then here is, to what extent is he guilty for publishing documents that were behind a firewall? The actual original documents that he was censoring were behind a firewall. Some of them publishes the password to unlock them, but it's to unlock them on his file. So basically, I guess it's up to a court to decide a level of culpability. Now, if Assange does go to the United States, if this extradition is successful, what do you expect to happen then?
Well, there are two aspects to that, Andrew. Firstly, he'd be tried in a court in Eastern Virginia. Eastern Virginia, this particular court is where generally most of these, if you can call security state type charges, are heard. One of the difficulties with this court is that it's got a very, very high conviction rate. Jury members in that court are selected from the local community. They tend to be family members of those who work in security and defence in Washington. So there are some issues, and I think some evidence is going to be called from lawyers saying, look, this is not really a court where, in relation to these charges, you can be guaranteed a fair trial. But the second issue is punishment. So the United States has said that he could get up to 170 years imprisonment. That's known in the US by anti-death penalty campaigners as what's called an effective death penalty, because there's no chance of parole. Now, of course, the lawyers for the US said on Monday, well, a lot of those sentences could be concurrent. In other words, you do 20 years, but it runs alongside another 20 years. The difficulty with that argument, of course, is that it's in the hands of the court. And we know in the United States, you know and I know, that, of course, often the courts will hand out sentences which are, you know, effectively the end of that person's life as a citizen in the community. So there are those issues. There are also a series of issues around his mental health, which will be explored during the course of this hearing, probably not this week, but in May when we go back into court, and about the sort of oppressive conditions in the US prison system. So there are a range of factors which are quite compelling. Can I just say, Andrew, on the issue of the penalty, the United Kingdom recently refused to extradite to India, I think, a couple who were wanted in relation to the murder of another family member on the basis that the Indian government had said they would get life without parole. And the United
On the other hand,
Kingdom
Greg, look, I understand this fear. But I have to say, with Chelsea Manning then released from jail, and she was the source of so much of this information, I don't know that he's got anything to fear about an 170-year sentence. I mean, technically, I guess you're right, but I'm less apprehensive about that. Now, finally, though, look, you're saying that if there was a release of names, it was, you know, because someone else did this and this and this, but essentially he did have, in one form or another, this secret information, including names, out there on the web. I'm just wondering, why should I be concerned that this is a free speech issue when that is information going to security of a country that I think's got a right to try to protect its sources? Why is this for you a free speech issue?
Well, can I just very quickly pick you up on the Manning point? That of course, was a military trial. And, of course, the sentencing regime has limits upon it that you don't have in the civilian sphere. The second point, though, that you've raised, or the point you've just raised, Andrew, there was a redaction process that was being undertaken. That's the point. But the point, there's also this point. What was revealed? What was revealed was some serious war crimes on the part of the United States. Now, Australia is an ally of the United States, as is the United Kingdom. But we're all conscious of being, as allies and working with the United States, that the United States prides itself on the rule of law and on working within the Geneva Convention in relation to the military rules that apply in a conflict. So, you know, it's an issue which is not simply one of left, right, and that's what I'm observing.
No, you've made that point. You know, good on you. No, Greg Barnes, thank you so much indeed for your time.
Thanks, Andrew.